The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. We're going to be starting at in about 2 or 3 minutes. We're just going to wait a couple minutes to let other people join. Okay, well, I guess we'll get started then. Good afternoon and welcome. Thank you for joining us for this virtual hearing on our proposed regulations for providing clear and reasonable warnings for cannabis, smoke, and Delta-9 THC. I'm Lauren Zeiss, the Director of the Office of Environmental Health Hazard Assessment, also called OEHHA. We appreciate your interest in these regulations and that you've taken the time to attend this hearing, and we look forward to your comments. Before we get started, I'd like to turn the hearing over to Trudy of GoToWebinar Support, who will go over some housekeeping details regarding how you can best participate in today's hearing. Trudy.
Thank you. Hello, everyone. I will be assisting with the logistics for the meeting today. You may have joined the presentation using your computer speaker system by default. If you'd prefer to join over the telephone, just select phone in the audio pane and the dial-in information will be displayed. You can join the meeting by participating in the webinar. Register at https://attendee.gotowebinar.com/register/361-289-117-002-367-8990. And you will get a confirmation email with a link to join the webinar. If you would like to access closed captioning, you can also access the live video stream with automated closed captioning at https://video.calepa.ca.gov/. You will have the opportunity to provide public comments about the proposed regulations orally or in the text format via the GoToWebinar link or on the phone. If you would like to call in to listen to the hearing, you can call 213-929-4212 using access code 187-572-358. If you're watching the live stream and you would like to provide a comment, you must participate in the webinar or by phone to be able to comment. How to comment. If you would like to speak, it would be helpful if you could submit a virtual speaker card, but it is not required. You can find it on the web at bit.ly/P65 Cannabis Warnings. If you have submitted a speaker card prior to the meeting, we have received it. If you have not submitted a speaker card, please submit it now. You will be called on in the order the cards are received. If you have not submitted a virtual speaker card and you would like to speak at today's hearing, can you please raise your virtual hand in the attendee box and we will make a list of the people who would like to speak today. You'll be called on after the speakers who have signed up to speak. You can also submit text comments to OEHHA by typing your comments into the questions pane of the control panel. You may send in your comments at any time during the presentation. I will now turn the hearing back over to Dr. Zeiss.
Thank you, Trudy. Shortly, our staff attorneys will give you an overview of the proposed regulation, and we appreciate the need for these safe harbor warnings for cannabis smoke and Delta-9 THC. And we also appreciate the need for customers and consumers to receive clear and reasonable, understandable warnings. We're looking forward to your comments on our proposed regulations after the staff presentations. Now I'd like to introduce Sam Delson, OEHHA's Deputy Director for External and Legislative Affairs. Mr. Delson is serving as the hearing officer today.
Good afternoon. My name is Sam Delson. Thank you for joining us for this virtual hearing. Under the provisions of the Administrative Procedures Act, this hearing was requested by the public for the presentation of comments orally or in writing regarding the proposed regulations for clear and reasonable safe harbor warnings for cannabis, marijuana smoke, and Delta-9 THC. The Office of Environmental Health Hazard Assessment, also known as OEHHA, considers this proceeding to be a quasi-legislative hearing because it is carrying out a rulemaking function designated to it by statute. OEHHA will consider all written comments and oral statements submitted or made during this hearing and respond to them in the regulatory process. OEHHA Director Zeiss has designated me to conduct this hearing on her behalf, and I will be doing so in accordance with provisions of the Administrative Procedure Act. The entire proceeding is being recorded and transcribed by a certified court reporter. The transcript and all materials presented at this hearing will be included in the administrative record for this rulemaking. Also, I want to make sure you're aware that because this is a formal public hearing, we will essentially be in listening mode today. Some of you perhaps have been to pre-regulatory workshops that we or other state agencies have held on early drafts of regulatory proposals, where there are often back and forth discussions with commenters. In this case, we may be able to answer procedural questions if you have any, or we may ask very simple clarifying questions of commenters. But formal public hearings are not really set up for the kinds of discussions you may have seen at other kinds of Proposition 65 related meetings and workshops. We're here to listen. If we adopt final regulations, we'll provide written responses to all relevant comments we receive at today's hearing, as well as written comments. If you have a detailed comment, we strongly recommend that you submit it to us in writing by the deadline so we can give it full consideration. The public comment period for the proposed amendments has been extended to provide commenters the opportunity to consider the information provided at this hearing when submitting their comments. The comment period will close on May 24th, 2021. For organizational purposes, those people who have submitted virtual speaker cards will be called on in order, and for those who have not, there will be time at the end of the hearing when you can raise your virtual hand and we will call on you to speak. We ask that in the interest of time, you limit your comments to 3 minutes per person. Trudy will be the timekeeper and will tell you when your time is up. In the interest of time, if you agree with the commenter that spoke before you, please state that when you're called on. There's no need to repeat the comments. To enable the audience to hear you, and to ensure that your comments are recorded for the record, please speak into your microphone when you're called on to speak. It's helpful to the court reporter if you state your name and the organization you represent, if any. However, you're not required to do so to speak. At this time, Christy Morioka, legal counsel for OEHHA, will provide some background information about the proposed regulations and the scope of this hearing.
Thank you, Mr. Delson. To save the time required to read into the record each provision of the proposed regulations, I have already provided a copy of the text of the proposed regulations, together with the public notice and the initial statement of reasons to the court reporter to have them included in the hearing record. As required by the Administrative Procedures Act, the public and interested parties were notified of these proposed regulations prior to today's hearing. The notice of these proposed amendments was published in the California Regulatory Notice Register and on OEHHA's website on March 19th, 2021. I would now like to provide you with a brief overview of Proposition 65. So Proposition 65, the Safe Drinking Water and Toxic Enforcement Act of 1986, also called Proposition 65, is a California law that was passed by direct voter initiative in 1986. Its goals are to protect drinking water sources from toxic substances that cause cancer and birth defects, and to reduce or eliminate exposures to those chemicals generally, such as in consumer products, by requiring businesses causing exposure to provide warnings in advance of those exposures at significant levels. Prop 65 requires the state of California to develop and maintain a list of carcinogens and reproductive toxicants. Prop 65 is enforced by the California Attorney General, local prosecutors, and private individuals acting in the public interest. OEHHA is the Prop 65 lead agency and adopts regulations for the public to follow, but has no enforcement authority. The penalties for violation of not warning or providing an incomplete warning are $2,500 per day per violation. OEHHA is responsible for listing carcinogens and reproductive toxicants. You can find the entire Prop 65 list on the OEHHA website, https://oehha.ca.gov, Proposition 65 list. Businesses are likely using the general consumer product warning for products that create marijuana cannabis smoke. OEHHA decided to adopt a specific tailored warning when developmental toxicity was added as an additional endpoint for marijuana smoke and Delta-9 THC in January of 2020, and THC was added to the Proposition 65 list. Now, you may have joined this hearing as either a manufacturer or a retailer, and your responsibilities are different depending upon what your role is. Today, we will focus on the warning regulations. These include guidance concerning who should provide warnings. So manufacturers have the primary responsibility for warning consumers. Manufacturers can label a consumer product or provide warning materials to the retailer. Retail sellers, which includes internet sellers, act as a pass-through for warnings provided by the manufacturer. And they also provide environmental exposure warning when required, such as when marijuana products are consumed on the business premises and smoke exposure may occur to the consumer. As a useful resource for you is OEHHA's Proposition 65 Warnings website, prop65warnings.ca.gov. This website has sample warnings and translations. It has frequently asked questions for businesses and sample internet and catalog warnings, among a host of other resources available for your use. If you haven't checked out this website, we encourage you to take a look here for some useful information. I'd now like to provide you with a very brief overview of California's regulatory process so that everyone understands where we are in the process and you have reasonable expectations about timeframe. And if you already know about this process, please bear with us for just 1 minute. So to start the formal regulatory process, OEHHA gives the public notice of the proposed regulation. For this proposal, it was on March 19th, 2021. Public notice consists of the proposed text of the regulation or amendment and the initial statement of reasons explaining the need for the proposal. Then there is a 45-day public comment period. This includes the time for a hearing if it's requested by the public. This time is for the public to submit written and oral comments about the proposal. For this proposal, the public comment period was extended to end on May 24th, 2021. After the public comment period, OEHHA reviews all of the comments and decides if any changes should be made to the proposal. If OEHHA decides changes should be made to the original proposal, those changes will be released to the public for comments. We release the amendments to the public by sending it to the listservs that we sent the notice of this hearing to, and also publishing it on our website. Then there is a 15-day public comment period for comments about the proposed changes. There is no hearing for any of those proposed amendments. Now, if OEHHA decides that there are no changes to be made to the proposal, then OEHHA will prepare responses to all relevant comments, including those from the hearing, and will submit the final regulatory package to the Office of Administrative Law, OAL. This process usually takes a couple of months to complete. OAL currently has 60 working days to review the package. If approved, the regulation is adopted when it is filed with the Secretary of State. Regulations are adopted and only effective quarterly, so on January 1, April 1, July 1, or October 1. Now that you have a background in the regulatory process, let's talk a little bit about the proposed cannabis and Delta-9 THC safe harbor warnings regulations. The proposed regulations would add clear and reasonable safe harbor warnings for cannabis smoke and Delta-9 THC. The regulations are intended to address concerns that the cannabis industry needs more guidance on how to properly provide Proposition 65 warnings. Now let's talk about the safe harbor warning methods for consumer products. So a safe harbor is non-mandatory guidance that, when used, provides a business protection from Proposition 65 enforcement actions. The safe harbor warning methods for consumer products are as follows. The first safe harbor method is a label that uses the specified warning language. Now, as a note, a short form warning, one that does not list the specific chemical or endpoint, is not sufficient to provide a safe harbor. The second form of a safe harbor warning is a product-specific warning on a posted sign, shelf tag, or shelf sign. Third is a product-specific warning on an electronic device, such as through an app. Fourth, for internet sales, a warning or clearly marked hyperlink to the warning. Fifth, for catalog sales, the warning must be clearly associated with the specific item. And as a last note, the warning must also be provided in other languages if other languages are used for other consumer information. Now let's talk about the warning methods for environmental exposures. These are when the use of a product is allowed on the premises and can expose people to listed chemicals. A warning must be provided to the public, in the case of an environmental exposure, on a sign at least 8.5 by 11 inches and printed in a greater than or equal to 22-point font. The signs must be at the entrance to and within the area where the exposure may occur. And if information is provided to the consumer in any other language other than English, the warning must also be provided in those languages. Now, let's talk about the proposed regulation. The proposed regulation would add specific tailored safe harbor exposure warning methods and content for retail products that can expose consumers to cannabis smoke, exposure from ingested products in dermally applied products, or vaping or dabbing products. The warnings are also for environmental exposure to cannabis smoke or Delta-9 THC from vaped or dabbed products in establishments where legal use of such products occurs. These warnings require the yellow warning symbol and the word warning in all capital letters in bold print, and the use of the specific safe harbor warnings provided in the regulation. The proposed regulation would also provide specific information to consumers about the risk of exposing a pregnant woman and her child to cannabis smoke and/or Delta-9 THC by including specific information about the risks associated with such exposure. Now, I would like to turn it over to Ryan Mahoney, who is going to explain more about the specific regulatory proposal.
Thank you, and good afternoon. I will go over some examples of the warning content for the proposed regulations. Next slide, please. This warning language is intended to clearly communicate the specific harm that can be caused by exposures from cannabis smoke and is worded as follows. Smoking cannabis increases your cancer risk and during pregnancy exposes your child to Delta-9 THC and other chemicals that can affect your child's birth weight, behavior, and learning ability. For more information, go to www.p65warnings.com/cannabis. This warning content, again, is meant to provide specific information related to the risks posed to pregnant women and their unborn children. Next slide, please. This slide contains the warning content for cannabis products intended for ingestion, and there are two variations. One for exposure to Delta-9 THC and another for exposures to Delta-9 THC and a significant exposure to one or more other Proposition 65 listed carcinogens. If such an exposure is occurring, the warning must include the name of at least one listed carcinogen. There is similar warning content for cannabis products intended for vaping or dabbing and for those intended for dermal application. Next slide, please. This slide contains the warning content for environmental exposures, such as those that can occur in locations where cannabis is legally smoked, vaped, or dabbed. There are three variations of this environmental warning based on the type of exposure. The example provided is for exposures to both cannabis smoke and Delta-9 THC, which would mean there is a designated smoking area where cannabis can be smoked or vaped or dabbed. The variants of this warning include warning language for situations where the only exposure is to Delta-9 THC, and that would be in a situation where a business has a designated smoking area that allows vaping or dabbing, but does not allow cannabis smoke. There is a third variation of this warning for situations where there is a designated vaping or dabbing area where cannabis smoking is not allowed, but that also causes exposure to one or more Proposition 65 listed carcinogens. If such an exposure is occurring, the warning must include the name of at least one listed carcinogen. Next slide, please. I will now turn it back over to Sam Delson.
Thank you very much, Ryan. We've now come to the public comment portion of the hearing. We have 5 people who've registered to make comments. And as a reminder, if anyone else wants to speak who has not registered, let us know and we can add you on after the first 5 have spoken. Our first speaker is Monica Barrera of Sky High. Are you there, Ms. Barrera? We'll give it a few more seconds and then we can come back to you if you're not ready now, but ready later. So, not having heard from our first speaker yet, I'll move on to the second speaker, Eddie Franco of the California Cannabis Industry Association.
Can you hear me, speakers? Thank you.
I can hear you, and let me just suggest that I understand there are some technical difficulties earlier that have now been fixed, and if you're still having technical difficulties, it might help to refresh your browsers, and that should get you up to date with full access. Go ahead.
Thank you, Mr. Delson and speakers. Eddie Franco, Legislative and Regulatory Affairs Manager with the California Cannabis Industry Association. As the largest cannabis trade association in California, CCIA respectfully opposes these proposed amendments to clear and reasonable warnings under Prop 65. These proposed amendments will add significant cost pressures and workload to our already overburdened industry, particularly during a period of great regulatory uncertainty. California's cannabis industry is one of the most highly regulated consumer industries in the state. Cannabis products must follow strict health and safety standards, including rigorous product testing for compounds and contaminants, labeling of all cannabis content, and many other regulatory protections and label warnings to prevent access to minors. Additionally, since cannabis or marijuana smoke is already listed under OEHHA's chemicals considered or listed under Prop 65 for both cancer and reproductive health, cannabis operators already follow all current guidelines related to Prop 65 warnings and disclaimers to consumers. We are therefore concerned that the cannabis industry's rigorous labeling requirements leave little room to accommodate these proposed amendments. As mentioned previously, all cannabis products sold in California must clearly disclose the product's batch number, cannabinoid content, expiration date, unique ID, and much more. Considering the size of most cannabis product packaging, it's unclear how operators can logistically accommodate these new proposed additions, particularly in light of OEHHA's other pending Prop 65 amendments under consideration around short form warnings. Moreover, costs incurred by operators to accommodate this proposed change would be very significant, only contributing to higher barriers to entry for legal operators and encouraging participation in the illicit market. Operators would need to remediate their current packaging or in some cases generate new packaging altogether after having just complied with a myriad of changes to packaging and labeling laws under the ever-changing cannabis regulations. For small businesses already operating under razor-thin margins, this could be financially devastating. Finally, these changes are being proposed particularly at a time of great uncertainty for the cannabis industry. Not only is the industry grappling with the fallout and recovery of COVID-19 pandemic as most industries in California, but we do not qualify for any of the federal relief or SBA loans that other industries have been afforded. Moreover, our operators are faced with the pending consolidation of the 3 licensing agencies into one and the many changes that may bring. With this consolidation will come many new potential changes to cannabis regulation and compliance. So yet another label change, the goal of which is already achieved in many ways through current regulations that are already being complied with, would just add greater confusion to an already uncertain time for our industry. So for these reasons, and we will be submitting written testimony echoing this as well, CCIA respectfully opposes these proposed amendments, at least until a time at which our industry is at a point of greater economic stability and regulatory certainty. Thanks so much for your consideration.
Thank you, Mr. Franco. Our next speaker is Judy Strang. Give you a few more seconds, and if we don't hear from you, we'll come back to you at the end of the list. Okay, I hope these speakers are not having technical issues, but we want to give everyone the fullest possible opportunity to express their comments on this proposed regulation. Next up is Suzanne Hume from cleanearthforkids.org.
Hello, and thank you so much. Good afternoon to everyone. Thank you to OEHHA for your important work to protect public health. Protecting pregnant women, children, and the public is vital. Thank you for the clear presentation today, taking action, and for all you do. It is so important that we move forward. My name is Suzanne Hume. I'm the Educational Director and founder of cleanearthforkids.org. Both cannabis smoke and Delta-9 THC are known health hazards. We support the warning label for smoking, vaping, dabbing in all capital letters and in bold print. So very important. Our youth and people today are simply unaware of the dangers of cannabis. I know this because I work with youth and have been a teacher for decades. Research has shown that cannabis and THC containing products are being marketed directly at youth, especially to youth of color. So this is a racial, social, environmental, public health issue. And thank you so much for taking these actions today. We do ask you to make this warning mandatory. It is so absolutely important. The DART Identification Committee has identified cannabis smoke as causing developmental toxicity. And we know that THC can cause birth defects and other reproductive problems, and also problems with children's behavior and learning. This is so important. Thank you for your actions today, and let's make this mandatory. Thank you so much from cleanearthforkids.org.
Thank you, Ms. Hume. Our next speaker is, and I hope I'm pronouncing this correctly, Jason Sarouche of the Public Health Institute.
Yeah, you did pronounce that correctly. Thank you. And thank you for this opportunity to speak. My name is RS Jason Sarouche. I'm a Policy Research Associate at the Public Health Institute. We support the proposed amendments to Article 6 and believe these heightened warnings will help discourage cannabis use among pregnant women. Our recent publication has found that pregnant women in California who live closer to cannabis retailers are more likely to use cannabis than women who live further away. Pregnant women with more retailers within a 15-minute drive had greater odds of cannabis use compared with pregnant women not living within a 15-minute drive of a retailer. Kaiser Permanente has seen major increases in use by pregnant women, and they're a very large cohort of pregnant women. The U.S. Surgeon General has published an advisory about the dangers of cannabis use during pregnancy. The Colorado Pregnancy Risk Assessment Monitoring System reported that maternal marijuana use was associated with a 50% increase of low birth weight, regardless of maternal age, race, ethnicity, education, and tobacco use. Many other studies have also shown that cannabis use in pregnancy is associated with adverse outcomes. So we know these warnings are important. California cannabis product label requirements do include warning statements, but in a weak 6-point font with graphic highlights or visuals and with vague language regarding pregnancy. First, we strongly support the proposed strengthening of warnings for consumer products and for environmental exposure. While the proposed language for clear and reasonable cannabis smoke and Delta-9 THC exposure warnings are a good step forward, we have some suggestions to ensure the public health messaging is clear to all consumers. Rather than allowing options for how retailers can post a proposed warning language, we suggest that all storefront cannabis retailers be required to display a warning sign with the applicable language posted prominently behind the main dispensing counter. The sign should be at least 2 feet by 2 feet and be displayed with its midpoint 5 feet above the floor, so it is near eye level for most people. If the retailer also allows on-site consumption, then the additional proposed signage should be required to be 2 feet by 2 feet as well, because an 8.5 by 11 inch sheet of paper with 22-point font is not very easy to see from 5 to 10 feet away. If the on-site consumption space is poorly lit, the warning should be illuminated. In the case of cannabis delivery services, which make up a significant portion of the market, a printout of at least 1/2 page and with 16-point font should be required to be handed out with all products that contain the applicable information. So thank you for your time, and yeah, we're here to help if you have any questions.
Thank you, Jason. That concludes our list of registered speakers. However, we had 2 speakers on the list who were not able to state their comments when called on at first. So I'd like to give them another opportunity if they're here and wishing to speak. First, Monica Barrera, are you available? Okay, and the other was Judy Strang. Okay, well, we don't see them among the attendees, but we do have 2 additional people who've raised their hands. And so our next commenter will be Tracy Stevens.
Mr. Delson, my name is Tracy Stevens with Governmental Advocates. On behalf of Natura, which is a fully integrated cannabis company here in Sacramento, as well as Body and Mind, which is a multi-state licensee operating in Long Beach and San Diego. We would like to align our remarks with Mr. Franco so that we don't duplicate, but we have the exact same concerns as CCIA regarding the duplication and impact on our industry. Thank you very much.
Thank you, Ms. Stevens. Our next speaker is Rand Martin.
Can you hear me now?
We can.
Okay, all right. So first off, I'm not sure what happened. I registered for this, but was not listed to speak. So I'm glad that I'm now getting the opportunity to do so. So first, I am here on behalf of CMG Caliva, which is the largest vertically integrated cannabis company in the state of California. Our primary concern with these regulations, the proposed regulations, is the real estate on the warning labels that is being crowded out by additional warning requirements. You know, it is very important for consumers of cannabis products to receive comprehensive warnings about what the product may or may not bring to them. and the Department of Public Health beat OEHHA to the punch about 4 years ago by requiring far more expansive warning information to be included on the labels than what you're proposing. For example, let me read to you in case you haven't seen this. We are required by statute to put on all of our products government warning: this product contains cannabis, a Schedule I controlled substance. Keep out of the reach of children and animals. Cannabis products may only be possessed or consumed by persons 21 years of age or older unless the person is a qualified patient. The intoxicating effects of cannabis products may be delayed up to 2 hours. Cannabis use while pregnant or breastfeeding may be harmful. Consumption of cannabis products impairs your ability to drive and operate machinery. Please use extreme caution. You would add to that, under these regulations, on products that fit in the size of your hand, an additional sentence at least: consuming this product during pregnancy exposes your child to delta-9 THC, which can affect your child's behavior and learning ability. For more information, go to www.p65warnings.ca.gov/cannabis. That is redundant information beyond which we are already required by statute to include on our labels. Mr. Frankel outlined several other things that have to go on the label, which again crowds out to the point where what the consumer sees is the visual equivalent of white noise. I want to point out one additional problem that everybody in state government that has anything to do with cannabis needs to be aware of. 3/4 of the products sold in the state of California comes from a very robust black market. Illicit operators prefer to risk the legal consequences than to abide by the regulatory requirements and taxation obligations. And while progress is being slowly made to try and curtail that black market, if others, including OEHHA, pile on more regulations, it defeats the progress that we're making so far, especially when the proposed new regulations are redundant of the existing regulations. We know you're just doing what you need to do in terms of your Prop 65 obligations, but at some point it's critical that OEHHA talk to DPH, talk to the Bureau of Cannabis Control, talk to the Department of Food and Agriculture, and coordinate what's being said so that we're sending a direct message, a clear message, not a redundant message, and that we don't make the labels useless to the consumer. We appreciate your time and thank you for your consideration.
Thank you very much, Mr. Martin. We have one more commenter who has asked to speak and like to repeat. If anyone else wants to add themselves to the list, please let us know. The next commenter is William Perno.
Hello, thank you. Can you hear me?
Yes, I can.
Thank you. I'm William Perno, and I agree with the Public Health Institute comments. I'd also like to note that what they mentioned about the warning font on the current packaging being a 6-point font. It's too small to be read, and there is no comprehensive warning if it cannot be read due to the font being too small. So where someone's reading this to you, please take a look at the actual packaging. 6-point font. The majority of people can't read that, nor will they even take time to look at it because the font characters on there are just too small. And that is what's in current state law, 6-point font. So everyone that's telling you it's redundant, I disagree because people can't read that 6-point font. I do support all efforts to address the illicit illegal marketplace, support for enforcement against those illegal businesses there. And the other thing I'd just like to note that while you're talking about delta-9 THC, please understand that there's now delta-8 THC and delta-10 THC. In particular, delta-8 THC can come from CBD products. So we're seeing websites selling this that are outside of Bureau of Cannabis Control and the other entities for regulating them because they're selling a CBD product, but they are selling it for human consumption, to be smoked, to be vaped, to be dabbed. And it's delta-8 THC. Delta-10 THC is something that they've also found now from the cannabis plant itself there. So while you're looking at these warnings, I just want to put out there on the table that perhaps it should be more than just delta-9 THC. The products that are smoked, vaped, or dabbed from the cannabis plant or the CBD plant, if that's also something that falls under these warnings, should be looked at. Thank you for your time and for having the meeting today.
Thank you very much, Mr. Perno. We have no others who have raised their hands. I'd like to give one more quick opportunity for Monica Barrera or Judy Strang to speak if they are here. Hearing none, I'll just ask again, is there anyone else who wishes to speak? As a reminder, if you're viewing the hearing on the Cal EPA website, then you'll need to log into the GoToWebinar or the phone line to comment. And the phone line is 213-929-4212. The access code is 187-572-358. Hearing no additional requests, I hereby close the hearing. Our office will accept written public comments until May 24th, 2021. Because of limited in-office staffing during the COVID-19 emergency, OEHHA strongly recommends that the public submit written information electronically rather than in paper form. Comments may be submitted electronically through our website at https://oehha.ca.gov/comments. Written comments can be emailed to Monet Vela, as you can see on the screen, monet.vela@oehha.ca.gov. Thank you for attending this hearing today.